Thank you very much, Mr Speaker. Happy to take a call on this debate on whether or not the contents of Supplementary Order Paper 173 in the name of Keith Locke should be able to be considered during the committee stage of this debate on the Governor-General Bill. And I think it's really important that the House and that those listening in and watching on TV are aware of what the SOP actually does. Because none of the speakers so far have actually talked in any detail about what that actually does. So Chris Tremaine mentioned, probably in more detail than most other people have done so far, what it actually does. And I think it's really important that we're not... Keith Locke, I don't think, is trying to pull a Swiftie here and slip in republicanism into a debate that has nothing to do with republicanism. These are matters that could... if you took a very wide-ranging approach to the scope of the Governor-General Bill, you could argue that they were within scope. And that was debated at the Select Committee when the submitters put forward that. We did have some discussion about whether or not, in fact, these should be in scope. So it's important that we talk about what they actually are. The first substantive amendment is the addition of a new Clause 4A, which deals with the appointment of the Governor-General, and that is the one that basically requires that when the Governor-General is appointed, that it is a 75% vote of the House of Representatives that confirms that appointment. Now, the question then becomes, is that something that's within the scope of this particular piece of legislation? The legislation that we're talking about, actually, I'll talk about Clause 5A because the points that I want to raise are relevant to both. That the addition of an additional Clause 5A, the term of appointment for the Governor-General, specifies in law that it's a 5-year term. The term should not exceed 5 years, and that a person who has been appointed Governor-General cannot be reappointed as Governor-General. So the question is whether those two changes, a specified term and a 75% vote of Parliament to confirm a Governor-General's appointment, are within the scope of this bill. The bill does deal with annuities for Governors-General, but there is no fixed term for a Governor-General. It deals with payments on conclusion of office, for example. So the idea of the term of a Governor-General being specified is actually relevant to the payment of annuities and so forth that are contained within the bill. So it's not as too big a stretch to say that it could actually be considered as part of the debate on this particular piece of legislation. As Keith Locke mentioned, both of these issues were raised during the Select Committee process, and I think, as David Parker pointed out, they were ruled outside the scope of the bill. Now, in that case, there are other process options that a Member of Parliament could choose to take. I have the Select Committee's report here on this bill. There isn't a minority report in the Government Administration Committee's report on the Governor-General Bill. That, of course, is one option that is available to members if they feel that significant issues have been raised outside the scope of the legislation being considered by a Select Committee. They do retain that option to put forward a minority report within the Select Committee's report, arguing that additional issues had been raised during the Select Committee process that are worthy of consideration, and alerting the House to those things. Now, the Government Administration Committee works on a very cooperative basis. It's chaired by the Honourable David Parker, and I can imagine that there wouldn't be any issue with the government had a member chosen to raise that and alert the House to that particular matter. I think that's an important part of our constitutional arrangement, that right of Select Committees to alert the House to matters that fall outside the strict scope of a piece of legislation that is being considered. That didn't happen in this particular case. So the question becomes, is this a case where there should be a specific exemption? You know, is this something that there should be an exemption for, and that we should therefore widen the scope? I'm a little uncomfortable about that because, having sat through the Select Committee hearings on this particular piece of legislation, there were several submitters that put forward, I think, quite compelling cases. I should point out, these are two amendments that I personally am very sympathetic towards. And two of the submitters argued that, yes, in fact, these amendments should go ahead. However, the other submitters to the Select Committee process, because it was not in the original bill, didn't get the opportunity to make comment on that. And so before the House were to consider those amendments in the committee stage, I would prefer that they went back to a Select Committee so that the public could have a say on it. It may be that there's a different appointment process for a Governor-General that the public of New Zealand, someone in the public may wish to be able to submit, and maybe a 5-year term might not be what people want. People may have a more compelling argument for a 4-year term or a 6-year term or some other term. So I think that given the significant constitutional nature of these and the extent to which it changes the role or the appointment process for the Governor-General and the role to some extent, because if you're making it a fixed term role, then that changes things. I think it's important that any such change be subject to a pretty rigorous examination process. The problem with doing it in the committee stage of the House is the public would not have a chance to have a say on it. Members would not have a chance to get their heads around it, do any additional research and so on. We're talking about the committee stage effectively being over and done with potentially in a day, and that doesn't give people much time to give it the depth of consideration that I think something of this constitutional significance should be able to should be the subject to. I think it's really important that Parliament as a whole tread very carefully when it comes to amending constitutional issues. And as Annette King has pointed out, if the government were of a mind to consider this issue, they could send the bill back to a select committee. And can I indicate, as a member of the opposition, I'd be very comfortable with this bill going back to a select committee with such provisions in it, because as I said, I think that they're very worthy provisions, and I think I agree with many things about republicanism with Keith Locke, but also about the role of the Governor-General, which is separate, and it's really important that we do keep those things quite distinct. This is not a Republican issue. This is to do with the Governor-General, the appointment of the Governor-General, the annuities paid to a Governor-General, the term of office of a Governor-General. That is within the scope of the bill in terms of the annuities and what the Governor-General is paid. But these issues are just, I would argue they're just on the margin, and they're just on the other side of the margin in terms of whether or not they're within the scope of this particular piece of legislation. So with some reluctance, I would say that I don't support the resolution put forward by Keith Locke to allow SOP number 173 to be considered by the Committee of the Whole. There are other avenues available to the member, and can I indicate that I would be very supportive of him should he choose to pursue those avenues that are available to him.
Mr. Speaker. Call Phil Twice.